We are going to round up the admissibility of evidence arguments that took place on the morning of day 93 of the YSL trial. After a week of what I would call pretty entertaining testimony from Woody, Kenneth Copeland, while on direct examination by the prosecution, particularly ADA Hylton, the prosecution is going to start this morning by moving to admit the full videos of police interviews that Woody has sat for throughout the years. I want to know what you think about the arguments both sides make here, especially since we're coming off the heels of last week where we got this affidavit from attorney Douglas Weinstein stating that upon information and belief on the morning of June 10th, this is the ex parte meeting, in Chief Judge Glanville's chambers in response to Copeland's statements that he would lie. ADA Hylton said she would not prosecute Copeland if he were to lie on the stand. So potentially there was suborning of perjury going on, and the prosecution was aware of this and not only let Copeland get on the stand anyway, but encouraged him that if you lie, we wouldn't prosecute you, except if you lie about this one thing, about killing Donovan Thomas Jr., then we would prosecute you for perjury. And Judge Glanville had denied this motion that Douglas Weinstein filed, and when Douglas Weinstein said, well, can you grant me a certificate for immediate review so I can take it up for an interlocutory appeal right now, that was denied too. So this issue that Weinstein requested, please resolve this is problematic, is not currently being resolved. The trial is moving forward. So we're about to watch the state make their argument that they want to admit these full Lil Woody interviews with the police. And they argue that this should be allowed because it shows the contradictions of Woody's testimony on the stand. And of course, this is all after the prosecution seems to have known that Woody was going to lie on the stand, but they still decided, hey, we're going to put him up there anyway, let him testify, and now we're going to use that lie as an excuse to let in these full videos, to argue that these full videos should be admissible, where they otherwise may not have been. So let's get into it. I'm going to cut out all the dead space. We're going to get right to the meat. And as you're going, let me know your thoughts on the arguments being made by the prosecution, the defense, and the judge.
Your Honor, given Mr. Copeland's testimony last week, the state does intend to play his interviews beginning today until whenever those interviews finish, at least for the January 11th, January 28th, February 20th, and February 21st interviews. Last night, the state sent over redactions as relates to the June 10th interview, which I believe defense counsel may have some portions that they also want to have redacted. And so the state would ask that we can move forward today with the first 4 interviews. We'll see where the day leads. And then tomorrow have some litigation if necessary.
Now, just for clarification, she's saying here, maybe today, 4 of the videos that we'll get through. Remember last week during testimony, we learned that one of these interviews was 8 hours long. Woody was interrogated for 8 hours, and we're getting this argument here. We want to play these videos in full. 4 of them today, possibly. Sounds like she's suggesting it would be longer than the trial day. But let's keep going.
Regarding the June 10th interviews.
Are you talking about the interviews which occurred where?
Back in 2015 at Atlanta Police Department, which the state believes could enter based on Mr. Copeland's testimony that everything he said in those interviews were lies, that he said anything that he wanted to say in order to get out of that interview, that we are impeaching him by contradiction and playing those statements. We will begin with the January 11th statements, and then we're going to move to the February 20th statement. And the reason why
January 11th and then February 20th, and those are 2015?
Those are both in 2015. And the reason why we're going to start with those two, Your Honor, we believe those two have the least amount of information that the defense may argue. So I think that those are easier to get through. The January 28th and the February 21st interviews, both of 2015, may have some more redactions that defense counsel may want. And so we're open to hearing what, if anything, they want redacted. So we can either consent to some things or have some litigation about that. But we're going to start with what I believe to be the easier interviews, which would be January 11th and February 20th. And then we'll move to January 28th, February 21st, and then June 10th of 2015.
Okay. All right, let me hear from any defense counsel about the state's plan to.
So again, the argument here is that they want to play these interviews essentially in full for the jury because of contradictions between what was said in these interviews and Woody's testimony delivered on the stand last week.
Play the January 11th and February 20th interviews.
So, good morning, Your Honor.
Good morning, sir.
So there's a couple things. Regarding just playing past interviews. It's going to be my stance on behalf of Mr. Stillwell and probably others that the foundation for prior inconsistent statements has not been laid in toto for the entire interviews to be played. Now, there may be specific snippets, but just to play the interview, we do not believe that the proper foundation has been laid. That being said, if the interviews are played, I understand what the state is saying, and Ms. Hylton communicated with me this morning, and I appreciate that. The first two interviews,
First two interviews, and tell me what date those are.
January 11th
And February 20th?
February 20th.
Okay. All right.
So those are interviews, and quite honestly, I've been focusing on the June 10th. I would ask that the defense have a little time just to look at those transcripts to just make sure if Your Honor is going to allow those interviews to be played over our objection or over our hearsay objection, to just make certain that there's nothing in those interviews that should not be played, that would fail 403 balancing, character evidence, etc. As we look forward, just for planning purposes, I have not, we were just sent the proposed redactions in a form that we could open them from the state. The June 10th interview, if it's allowed, is very problematic as far as Mr. Copeland talking about things he doesn't have personal knowledge of, talking about hearsay, bad character. It's just a very.
I think they want to litigate that separately.
Well,
so tell me about they're saying it's going to take a minute to get through the June 11th and February 20th interviews.
I understand that. All I'm saying is I'm just trying to give Your Honor a heads up that the June 10th, there may be a substantial amount of time that we may be asking for your attention outside the presence of the jury. I'm just trying to give the court a heads up on that.
Okay, but
yeah.
So I think the state says that too. So
okay,
there's
so
a disagreement about that. So
the first two interviews, I would just ask that the defense team be allowed. I don't know if the state is planning on going into it right now. If they are, I would ask that we be given some time to just review it, because we were not anticipating this morning, and just comparing our notes to see if we have any objections.
Well, I think that, well, let me just correct you just a second. Friday, the state did tell you that they planned on playing those two, at least they planned on playing those particular interviews in total for impeachment. They said that up at the bench on Friday.
Okay.
So you had all weekend to kind of go through that if that were the case. It's not like they're playing hide the ball. It's not like, given the current testimony so far, that wouldn't be probably a realistic possibility.
Well, I mean, we do have our objections, or I have my objections to that. But again, Your Honor, I would just ask that the defense attorney be allowed to huddle up and figure out, because I'm up here, but I'm not necessarily speaking for everyone, and I'd like the opportunity to communicate with counsel for the other defendants.
How long you had the January 11th interviews? You had them. When were they?
Probably. I mean, it's not Judge. Just to be clear, it's not a matter that I haven't watched them. I probably watched them 24 times.
Okay.
But it's just a matter of having the transcript pages where there's problematic issues.
Okay.
And again, Your Honor, I haven't looked at what the state's redactions are. They sent something at 11 o'clock last night with proposed redactions. It wouldn't open, so they resent it this morning, probably, 20 minutes ago. So I haven't had a chance to look at their proposed redactions.
And you want to be clear, the redactions are for the June 10th interview.
Okay, see.
The state believes that, again, for the January 11th and February 20th, we don't have any redactions for those two. But again, we're open to hear whatever.
Let me ask you another question. Mr. Schardt indicated that he doesn't believe that the foundation has been laid for prior inconsistent statements. You want to address that?
Yes, Your Honor. We're not asking to bring this in for prior inconsistent statements. We're asking to bring it in under 24-6-607 and 24-6-621, which is impeachment by contradiction, in which a witness may be impeached by contradiction in several ways, either close questioning, and I'm reading, Your Honor, from Carlson's on evidence, page 265, 8th edition, page 265. A witness may be impeached by contradiction in several ways: close questioning to elicit concessions of error, 2, questioning a witness about the substance of implication of evidence already produced during the case, confronting the witness with his or her own contradictory prior statements. And that's what I want to focus on, Your Honor. Mr. Copeland testified repeatedly during trial last week that everything he said in those interviews was a lie, that he was just saying whatever.
Now, I do want to pull up, Kathy Rousson has posted, let me make a giant here, But she did lay out the dates. So the state wants to play 5 of 6 total interviews, and she has the dates here listed out as January 11th. So really 2015 for 5 of them, and then 1 in 2021. So January 11th, January 28th, February 20th, February 21st, June 10th, all in 2015, and then an October 27th, 2021 interview, which was leaked. I think that's available on YouTube elsewhere. So I thought it was really helpful to see, the dates here and kind of get a framework of when this was taking place. You've got these clusters of 4 in January and February, and then this June one that they keep mentioning would be almost 4 months later after those 4. And then you've got one more interview all the way in 2021. So I thought this was helpful. So shout out to Kathy for that. Thinking about what Hylton is saying here is this isn't the typical argument for impeachment where we're able to admit something to show a prior inconsistent statement. But here Hylton is arguing that we should be able to get these videos, these interviews in full, because what he testified about them is a contradiction to what he said during these interviews. But what's the contradiction she's going to argue? She's arguing that the contradiction is that he said on the stand that he lied in these interviews. So I'm going to default to you guys. What do you guys think? Because to me, the contradictory argument would be if he was on the stand last week and at one point said, I didn't lie in those interviews, I told the truth. And then he also said, I lied in those interviews, I didn't tell the truth. But really what we have with Woody is not this blanket statement that contradicts itself in whole. In fact, he pointed out that I told the truth about simple things, such as a shoe color, to let them think I was telling them the truth. And then, beyond that, I told them whatever it was they wanted to hear, so I could get out of there. And he maintained that same theme, in my opinion, throughout his testimony. And then again, all of this is in the context of this affidavit being out there that is saying that Hylton allowed this witness, Lil Woody, to go on the stand after being told by him that he would lie. And she tells him, well, I wouldn't prosecute you as long as you don't lie about who killed Donovan Thomas on the stand. So this is just a crazy, crazy argument to me. It's really sitting in my head like, what? So let's keep watching it play out. Let's see where we go.
Whatever he wanted to say in order to get out of there, that the officers were pressuring him to speak about Thug, that in the first interview, he did not come down there on his own. He only came at the request of law enforcement. And we believe each of these interviews contradict everything that he testified to in before this jury, Your Honor. So we believe that at this point, it is right to show impeachment by contradiction.
Well, and if there's certain things that are said that indicate that the officers did not pressure him about quote unquote thug or things like that, that maybe fall under contradiction. But playing the whole video, it's like they're saying he said he lied, and we're bringing this to as contradiction, evidence of contradiction. But that would be assuming that he's telling the truth in that interview. It doesn't in and of itself facially contradict anything he's saying. He's just saying he lied.
Ordinarily, you'd be right. It would be impeached as to specific things. The challenge in this particular circumstance is that Mr. Copeland repeatedly said, I lied about everything. And I lied I told a lie as to what would get me out of this. So I think under those circumstances, this is kind of the broadening of it because of his testimony. The entirety of that particular interview is probably going to be admissibly played. Respectfully, over your objection.
I understand, but this is a problem that was created by the state, and they're trying to.
Just slow down. How did the
Cutting
state
him off.
make this a problem when the witness testified, not just once, but repeatedly over the last several days, that he has lied about these particular interviews? He was lying because he wanted to get out of this. He told these people anything that he thought that would work. And so that's kind of the predicate. Ordinarily, sir, I would agree. I would totally agree with you, but I don't think the state set this particular witness up for that particular saying. He said it more than.
The judge himself just said, I don't think, as you're saying, Mr. Schardt, I disagree that with your theory that the state set this up, essentially to put the witness on the stand, knowing that they were going to lie, to open the door for these full interviews to come in. And the judge here just said, no, I don't think that the state set this up with this witness.
Once.
Okay, I'd like to answer your question about how the state set this up. The state, we know that the state met with Kenneth Copeland what was it, 2 weeks ago now? We know we were arguing about whether his attorney was alerted, et cetera. They met with him, I guess, in the courthouse. I don't know. We know that they met with him. Unlike every other witness, they've done this with several of the people that are alleged to be associates of our
Trontavia Stevens,
clients.
YSL Slug.
They have been asking about statements from 10 years ago, and they intentionally have not allowed these witnesses, not afforded these witnesses an opportunity to review their past statements prior to testifying. So they want to play their past statements. They want, I don't recall. And so they bring these gentlemen in, ask them about statements that were made 10 years ago, and have never given them an opportunity. We know that the state, they're thorough. We know typically in trial, when the state is calling a witness, they say, hey, we want you to come into our office. We want you to sit down and review what you said in the past. And they do that regularly in trial prep. They have chosen not to do that for Kenneth Copeland. They chose not to do that for Trontavia Stevens. They have chosen to keep these gentlemen in the dark and then ask them questions about statements they allegedly made 10 years ago. And when the gentlemen say, I don't recall, which is pretty understandable, they say, we get to get into prior inconsistent statements. We get to get into impeachment by contradiction. That was their choice. They should have let these gentlemen review their statements before taking the stand, and we probably would be in a different place. So that's why I'm saying this is a bit a situation that they created. It was strategic by the state, and they shouldn't benefit from it.
Okay.
Your Honor, I'll respond to that.
Madam?
No.
Yeah, no, yeah, go ahead.
Your Honor, Mr. Schardt keeps addressing, again, prior inconsistent statements. What we expect for any of our witnesses to do is come in here and tell the truth about what they remember happening in 2015, given why they're here. What Mr.
She just said that they expect the witness to come up here and tell the truth. But that's not what we have here in Douglas Weinstein's affidavit. Instead, we have, on the morning of June 10th, that ex parte meeting, ADA Hylton stated that she would not prosecute Copeland if he were to lie on the stand. Like, I don't think I have more thoughts to add than that. I'm just, how do you say that? Let's keep going.
Copeland said is, everything I said was a lie. So at this point, Your Honor, it's not about, he literally saying, everything I said is a lie. I told them lies back in 2015 just to get out of trouble. And what we are saying now is, we don't believe that to be true. The jury can make an assessment based on his trial testimony and what he said previously, and determine by his body language, by how he testified, by how he spoke to law enforcement about what was asked of him, how he responded, whether or not they believe that everything he said previously is contradicted by how he acted in court. And so again, Your Honor, Mr. Schardt is focusing on prior inconsistent statements. Again, we're impeaching by contradiction, meaning what he said in court is distinguishable from what he said previously in 2015, one, outside of the presence of these individuals, and how he testified, which was that line of questioning that we asked of Mr. Copeland.
Okay. Anybody else wish to be heard on this issue? Mr. Steele? You can come to the podium, sir, if you'd like. Maybe it'll be easier for you, but.
So my notes do not reflect that Mr. Copeland gave a blanket, everything I said previously is a lie. What I have is he would answer some questions, probably did. Other questions, yes, I remember that. And some questions, that was a lie. So we need to go, we have a duty not to just play prior statements that are not inconsistent and do not impeach current testimony. In addition,
They're not saying it's impeachment. They're saying testimony by prior contradiction.
it's an impeachment way to do it, but it's not impeachment for some things. Other things, sure. He said, I said anything to get out of trouble, to get the police to stop investigating me, or words to that effect, and put them on someone else. Also, there are detectives. There is Detective Thorpe in the January 11th, early morning hours, 2015, video, audio recording, and there are other officers. Those officers give statements as well. Now, some of the statements have to put in context, so the rule of completeness. However, other statements, the detectives are giving information that do not put anything in context. It's their opinion. So I do believe, I agree with everything and endorse everything Mr. Schardt said, but I do believe that the state needs to be more focused and not just say they're playing everything. And then obviously bring it to the court with any other issues that we have. If the state's position is what it is, then my position is that the court needs to make findings on each line, because they're not all inconsistent under 24-6-602.
So we're saying go
or
line by
anything
line.
on 24-6-613.
All right, Chris.
And that makes sense to me because I remember Woody saying, like, I might have said that, or that sounds like me. He wasn't fully, no, no, no.
Ms. Weaver, just to see if she could find that particular part of the record on Friday. So we're going to see if we can search for that. Anybody else wish to be heard on this issue? Okay. Chris, how long will it take you?
Okay, they're going to take a 5-minute
Okay,
recess.
we're
That
gonna
takes a
recess
very
for 5
long
minutes,
time.
and
So, 40-minute break.
all right, Ms. Weaver's had a chance to review in a cursory manner the current transcript or testimony of Mr. Copeland. We're not finding anything that comports with what the state said in terms of everything I said was a lie. All right, the closest that I have, and I'll include this, is her email to me as an next court's exhibit. Question: do you recall telling Detective Dennis and Gaither that I wouldn't want anybody around me but Lil D? Answer: I probably said that because I was trying to run a play on them, but I don't remember what was said. Question back in: anytime they question me, like I said, you keep asking me about what I supposed to have told them. Anytime they question me, I said whatever came to mind or whatever I thought of in that split second. So I don't know what I said to them. Question: do you recall telling Detective Gaither and Dennis, quotation mark, I really must have my trust in him, close quotation mark, speaking about Little D? Answer: you said I really had my trust in him? Question: yes, yeah. Answer: no, man, go ahead. Question: and that Little D ain't never going to turn his back on me? Answer: I told you I was trying to tell them whatever they would have went for because yeah. Question: you recall telling detectives in those interviews that you were just trying to get out of jail, so I'm going to tell you all what happened so you can check it and I can get out of jail? Answer: yeah. I told the investigators what I remember. I think in one of the interviews, they was locking me up and my child's birthday was coming. And when they got me, I said, listen, man, whatever you all want me to say, I will tell you right now. Just tell me what to say and I'll say it. Tell me what you all want to know and I will tell you. So if they would have asked me about President Trump, I would have told a story about Trump. If they would have asked me about you, I would have had a story about you. Whatever to convince them that I ain't doing nothing, it wasn't me that's what my intention was. So when you're asking me about interviews, I keep telling you, you keep asking me step by step, by step, by step, by step, by step, by step, by step. This is what I did. When they got me on this day, I was going to jail. I tried to come up with something to tell them. That's why I can't tell you what I said. I was making it up. State, unless you've got something more specific, it looks like from looking at 607, it allows for the admission of intrinsic evidence to impeach specific errors or falsehoods in the witness's testimony on direct examination. So it's more so, they give the case of United States versus, this is in Carlson, Antonius, and that's Antonokeas. And this particular accused was charged with illegal narcotics offenses, and when he testified, he made sweeping statements about disavowing any involvement with drugs. So the government provided testimony that from somebody that had sold him cocaine on 2 occasions, or they asked him about it. So sold him cocaine on 2 occasions. So if you open the door, I don't think, which is what I think you're trying to tell the court, but I don't think it's quite broad enough. I haven't found anything in the transcript that indicates that what you said, everything I said was a lie. That's broad and would probably open that up, but I haven't found anything. I think you're going to have to probably pare down your examination or.
So at first here, he's saying, yeah, I'm going to lean with the defense. There needs to be some specificity here. It's not just going to be the full interview can come in and be played in front of the jury. But
Rethink what you want to do in terms of 607.
But Your Honor, when he says in court, I was making it all up. That is,
Says I was making it up.
I was making it up, meaning everything that he told law enforcement back then in order to get out of whatever he was doing, I was making it up. We don't believe he was making it up. We believe that he was being truthful in those interviews. And so when he comes in court and says, I was making it up, meaning I was saying anything in that interview room in order to get out of custody or to get out of that interview, then everything I'm saying isn't true. Because that's what he's saying. I was making it up. That's what he told this jury, that everything I said back in 2015, I was making it up.
Let me read the last sentence, 2 sentences again. Okay, let me just kind of think about it. So when you're asking me about interviews, and I keep telling you, you keep asking me step, and there's like 7 by steps, by step, by step, by step, by step, by step, by step, by step. This is what I did. When they got me on this day, I was going to jail. I tried to come up with something to tell them. That's why I can't tell you what I said. I was making it up.
Right. And so we don't believe he was just making it up. We believe that's what he's telling this jury. And so the jurors can see his demeanor in all of the interviews. They can assess whether or not they think he was making it up or not. But at this juncture, what he's saying is anything I told the police back in 2015, I was just saying it. I was making it up. And at this point, the jurors can either believe right now what he's saying, or they can look at what he told detectives back in 2015, how he said it to detectives in 2015, who all was in the room with him in 2015, and make a determination, is what he's saying in court contradicted by what we see in these prior interviews with him. So that is the contradiction, Your Honor. I was making it up is a complete contradiction to what he was doing in those interviews in 2015. So that is, maybe he didn't say I lied, but he said I was making it up. That is, I wasn't telling the truth. Now the jurors can look at interviews to determine whether or not they believe, was he making it up just to get out of trouble, or was he being truthful in 2015 when he made those statements to law enforcement, Your Honor.
All right. Mr. Schardt, bless you.
God bless you.
Mr. Schardt or Mr. Steele, gentlemen.
Oh, and additionally, Your Honor, I believe he said, and I would think you had to look at the January 11th interview. When we questioned him about January 11th, he said, and I'm looking at notes, but we would ask the court reporter to confirm.
Remember, January 11th was that first interview. It was the day after Donovan Thomas was killed.
I don't remember anything that I told Detective Thorpe at all. And so again, we believe that he's being contradicted by what he's saying in court versus what he said in 2015.
Okay. Mr. Schardt.
I think you have it exactly right, Judge. These rules are not so broad as to just allow hours-long statements in based on specific denials. The idea that I think you also should consider is within your purview to consider the gamesmanship.
I'm going to stop you there. I don't think that anybody's playing any running games in terms of that.
Well, I don't.
Doesn't
I
want
think
that on the record.
I respectfully disagree with you about that. Okay?
So you don't think that they specifically chose not to show this gentleman his videos so he would not recall things when asked about
I don't think
10-year-old
any-
statements?
I don't think that any self-righteous advocate worth their salt is not going to prepare a witness. I don't believe you would do that. I don't believe anybody would do
Well,
that.
why hasn't he seen the videos?
I don't know, sir. I don't.
Okay.
I don't. And I don't know what their prep entails. But again, we're not going into, ad hominem attacks against anybody, okay?
It's not an attack. I just think it was strategy, and they shouldn't benefit from the strategy. I'm not making a personal attack. I mean,
No, but there are pros and cons about how witnesses are prepped. So, I certainly,
right.
I certainly think that is something that, has to be taken into account depending upon the witness and depending upon the circumstances.
But they're trying to say just because he doesn't remember, recall, or denies specific parts, somehow this opens up the entire statement based on, well, the jurors should get to see his demeanor. And again, they can see his demeanor on the specific part that is being impeached. And impeachment
But I'm concerned about this last couple statements because he says, when you're asking me about interviews, that's broad. He's saying in these interviews that I have been undergoing, I keep telling you, you keep asking me step by step by step by step by step, this is what I did. So when they got me this day, I was going to jail. I tried to come up with something to tell them. That's why I can't tell you what I said. I was making it up.
In my observation is he's frustrated because he doesn't understand the rules of evidence. He doesn't understand that the state was trying to lay a foundation for prior inconsistent statements. But just because he's frustrated and doesn't answer the question, and it, quite honestly, is non-responsive, that doesn't mean the foundation was laid. They still have to lay the foundation.
The impeachment and or the prior inconsistent statement is a collateral consequence of what the witness testifies to. If the witness gives pretty straightforward testimony, then there's no need to go into any of the other things about prior inconsistent statements or impeachment by contradiction. It doesn't come into play because there won't be anything for them to kind of bring out. So it depends on the testimony of the witness as to whether or not we even broach the subjects of impeachment or by any means or method.
And what I think maybe the advocates aren't doing the best job conveying to your honor. The first two statements are pretty straightforward, okay? But as we move on, these statements are very
Are you talking about the statements on January the 11th and February 20th?
They're pretty straightforward and pretty compartmentalized, fairly compartmentalized about what they talk about. I'm going to use June 10th as an example because I mean this is going to come up again and
Okay,
again.
but I don't want to talk about June 10th.
Well, I don't want to set a precedent
we haven't kind of covered that. I have a jury that's sitting out here. I want to kind of see if I can go forward with that.
Okay, well-
So that's my intent at this point in time is
So he wants to move everything along forward now, but there was no problem holding a 3-hour meeting last Monday while the jury was waiting to enter the courtroom to hear testimony.
to see whether or not I can make an agreement, or not make an agreement, but I can make a decision as to whether I'm going to allow the state to play these two interviews.
Okay, well, I'm just trying to make it clear to your honor.
We can go into argument about that because even the state has told me that we probably will need to have some discussion
Okay,
about that.
I don't,
okay?
your honor's going to rule. I agreed with your honor's analysis initially. Your honor's going to rule how your honor rules. I just want to be clear that all of these statements are not the same, and any decisions made about the first statements should not be
I'm just
considered
talking about the
precedent.
first two
I got
right
you.
now. Okay, so
I'm going to stand by my objection on hearsay grounds.
Sure.
And I think I speak for all my co-counsel or co-defendant counsel regarding that. And your honor will just, it's a call that you're going to make and we're going to have to deal with it. But that's our stance.
Mr. Steele, anything else, sir? Okay, all right.
And we agree, Your Honor.
Anyone else? Mr. Harvey? Yeah.
I, at this point, renew my motion for severance and for a 105 instruction. None of this relates to Mr. Nichols.
Okay.
So I know you gave me a continuing objection. I want to renew it every now and then when
Sure.
we get into a position where there is a great deal of evidence that's coming in, none of which impacts Mr. Nichols.
All right, sir. So noted. Your motion for severance and your 105 request for a 105 instruction. I'm still going to deny it. I'll give you a continuing objection. All right. State, were you going to say something else, madam?
We agree as to the February 28th, January 28th, February 21st, and June 10th. We will probably need to have some litigation. That's why the state just solely wanted to focus on first, January 11th, and February 20th.
All right. Does the state have any case law you'd like me to rely upon? Either the defendants counsel as well. Is there any case law you'd like me to look at?
Yeah, again, we're solely reading from, at this juncture, but I can quote case law as well, from Carlton, when we're speaking of 24-6-607, again, referencing page 265 of the 8th edition. I'm sorry. However, the state will pull case law directly on point with this assertion, Your Honor.
Here's the challenge that I'm kind of coming into. It's 607 allows for the admission of to impeach specific errors or falsehoods in a witness's testimony. So it's not really broad. It's kind of
Right, and so we're looking.
It's focused. Okay, so.
And we're looking at it in conjunction with 24-6-621, which is impeachment by contradiction, Your Honor.
All right.
24-6-621 states that the witness may be impeached by disproving the facts testified to by the witness. So when he says in court, I was just making it up, we believe that we can now show this interview, these two interviews specifically, that he's not just making it up, anything that he says. We talked specifically in the February 20th interview about snitching. And he says, Tay's not the one who shot me. Matter of fact, he emphatically says, I know right now, I think he may have sworn his daughter's life that Tay did not shoot him. However, in the February 20th interview, he tells his girlfriend in a private conversation, well, not private, but in a conversation between the two of them, I know who shot at me. It was Tay. And so we questioned him about that instance as well, in conjunction with what happened with him, his daughter, and his child's mother. So again, both the January 11th interview, as well as the February 20th interview, is a complete contradiction to what he has said on the stand. last week, Your Honor.
All right. Based upon OCGA 24-607 and 24-621, in the court's review of the
So he's going to let those 2 interviews come in.
for the witnesses, Mr. Copeland's
January
testimony
11th,
thus far.
February 20th.
I'm going to allow the state over objection to play the interviews on January the 11th of 2015 and February the 20th of 2015. I will give all defendants a continued objection as relates to those 2 interviews. Those are the only 2 we'll take up at this point in time. And then, as we mentioned, we'll take up the other ones a little bit later, okay?
Your Honor, I do have a case for the record.
Before they testify. All right.
The case is going to be United States versus Carthen, Carthen, 906.
Is it 11th Circuit case?
Yes, Your Honor.
Come on. Can you spell that again?
Yes, United States versus Carthen, Carthen,
R-T-I-T-H?
Carthen.
It says it decided January of 2013?
2018.
2018. All right. You need to give me a citation. Go ahead.
Sure, 906,
Hold on. Go ahead.
Federal 3rd, 1315. God bless you. And has impeachment by contradiction occurs when a party offers evidence to prove that a fact to which a witness testified is not true.
Okay, 608 won't get you there. You're saying it's 621? Yeah, because a majority of circuits, you know, I believe under. All right. Okay. The court's still of the opinion that those 2 statements on January 11th and February 20th of 2015 can be played for impeachment by contradiction. All right. Bless you, Mr. Weinstein. When's your replacement coming? Not soon enough? Okay, all right. Hang in there, all right? Okay, all right. Sergeant Brown, summon our jurors, please.
So the jury's going to come back in. So that is the final decision from the court for now. It seemed like he was leaning towards the defense, and then he heard further arguments, and he said, all right, at least for the January 11th and the February 20th videos, they can come on in, get Woody back in on the stand. And we're not going to go too far into watching this testimony. Again, I always recommend, Nick Starr Trial Watch. There's, I think it's Fox 5 Atlanta. The lead attorney is actually still covering these trial days in full on his channel. So if you want to watch the full testimony, the full days, go check out those channels. I do want to highlight some bits from Woody that were very comical right as he takes a stand. But if you do want to dip out right here, let me know. What are you thinking about these arguments? Do you think, in conjunction with that ex parte meeting, that this was a strategy on the prosecution's part to make sure that these interviews would be admissible, particularly this January 11th one, right after the day that Donovan Thomas was shot? Do you think this is just a natural way that they're trying to deal with a difficult witness? They didn't intend for any of this to be the case, and they genuinely thought he would get on the stand and tell the truth? There's so many ways that we can have a discussion here, but let me know your thoughts in the comments, in the chat if you're watching this on the premiere. I had so much fun last week looking through all of the insights you guys shared. So I'm looking forward to that for sure. And to close this out, let's see some more fun moments from Woody. So hold on, did he have counsel here? Hold on, look at this. He's walking in, that lady's not here. Is that new counsel, maybe? Watch this. Watch the court reporter.
I'm tired.
So he agrees with his good friend, Kristen, the court reporter, to stand up for the jury, even though he's tired. Also get another moment. Pretty hilarious, pretty quickly.
All right, Ms. Hylton, you may proceed when ready.
Thank you. Good morning, Mr. Copeland.
Good morning.
You have permission to approach?
No. She's asking me that, Mr. Copeland, okay? All right.
Okay.
Counsels, you want to take a look at what counsel for the state is going to show you?
He's already over this. So they're gonna start playing these interview videos. I've got one more moment for you.
Yeah, but-
So the number is not broadcast, and I'm gonna move it to 3/12/58.
All right.
Oh, y'all still going?
So y'all still going. So we'll close that out with the little bit of flair that we're coming to know Lil Woody for. But again, the point of this video was to really break down this morning's arguments before testimony started. So we're still on direct examination on day 7 with Lil Woody. Direct examination will likely continue into tomorrow and maybe a good portion of the rest of this week. And now in front of us, we've got these videos. We've got these videos where he's speaking with police and he's giving statements, you know, the day after and then a month after Nut Donovan Thomas was killed. So at this point, the floor is yours, you guys. Let me know what you think of today's morning arguments, what you think of these videos coming in, what you think of Lil Woody's testimony as a whole, anything at all. Floor is yours. I appreciate you guys so much. Take care now. Bye-bye.